Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Red Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional, providing practical privacy advice to overwhelmed companies.
Hello, Justin Daniels here. I am a technology attorney who is passionate about helping companies solve complex cyber and privacy challenges during the life cycle of their business. I am the cyber quarterback helping clients design and implement cyber plans as well as them manage and recover from data breaches.
And this episode is brought to you by, love my drum roll, Red Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, SaaS, media, and professional services. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there's greater trust between companies and consumers. To learn more, visit redcloveradvisors.com. Today's super fun.
Yes, I see you're very perky today.
I am. I had my coffee.
Okay.
But it's a 2-for-1 special.
That it is. It's like Connect 4 today.
It is Connect 4, except in our 3 boxes.
There you go.
So we have very special guests from the amazing Perkins Coie law firm.
Yes, we do.
You're going to kick us off?
Yeah. So we have David Biderman, who leads Perkins Coie Consumer Products and Services Litigation Practice and its Food Litigation Industry Group. David has an active litigation practice in federal and state courts throughout the country for 39 years. He has litigated some of the most consequential food litigation matters in this emerging field and has established precedent in preemption, the reasonable consumer doctrine, and consumer protection law.
And we are joined by my longtime friend, Dominique Shelton Leipzig. She is known for asking deep questions that provoke transformative answers. And as the chair of the Global Data Innovation Team and co-chair of Perkins Coie's AdTech Privacy and Data Management practice, she focuses on privacy, data strategy, leveraging data, and avoiding litigation. And when you need an expert, you want the person who wrote the book. And her landmark book on CCPA has published a second edition. Make sure you get it. And she pioneered the concept of data as a pre-tangible asset in what she calls our post-data world. She's trained over 18,000 professionals on the CCPA and is a member of the IAPP board and leading advocate for data ethics. We are so excited to have both of you here today.
Hey, nice to be here.
Wonderful. So I'm going to let you all decide who goes first. But we always like to know, how did you find your way to the path to privacy and all things data related?
Dominique always goes first.
Well, first of all, great to be here, Jody, Justin. It's, a long way path to privacy has been working and collaborating with Jody, both as a client contact and then in your consulting firm as someone that we've collaborated with. So just a plug for how amazing Jody and Red Clover are. So my journey really started in 1998. I went to a law firm that did really, I guess for a tiny firm, we were only 70 attorneys, 35 partners, and I was the 5th associate in Los Angeles, but we had 35 associates. But one of our counsel, or I guess associates, had left and gone to a new company at that time called Yahoo. And he called one of our trial attorneys, Michael Kahn, so the firm was Folger, Levin and Kahn, Peter Folger of the Folger Coffee family, and then John Levin, whose father Jack Levin was very active in LA business, and then Michael Kahn, who's a renowned trial attorney. And so when Yahoo ran into issues, John, who eventually became head of litigation and eventually general counsel, reached out to Michael Kahn. So I guess we didn't really think of it back then as privacy litigation. It's just what everybody in the firm did. This is literally one of our top clients. And so I grew up with privacy and ad tech being sort of, and litigation being completely intertwined in my mind and in my mindset. Just continued that on to another New York law firm that was a bigger platform. I was at Folger for about 10 years. And I just continued the digital practice, founding the privacy practices of 3 other law firms in Los Angeles. And to where I am now, working with David, no longer litigating. I haven't litigated in about 9 years, but I do sympathize and understand completely what the litigators have to go through in terms of defending clients. And so that's what I try on the counseling side to deliver or help, the clients get as close to compliance as they can. So in the inevitable time when they are sued, there's hopefully less work for David's team, but I'll turn it on to David.
Yeah, thanks a lot. Hey, it's good to see you all this morning. Thanks for inviting us. Yeah, my journey is not as direct as Dominique's. I as you said, Justin, I've not 39, 40 years, 40 ugly years practicing law. So I've had to reinvent myself many times. And I'm a class action litigator, and I've litigated class actions. I actually litigated some cases with Dominique's old firm when we were on the same side of the V. When we were representing another platform years ago, Dominique. You probably don't, maybe before your time. It was one about gambling sites on the internet. Remember that one?
I remember that. I wasn't on that case, but I
yeah.
remember when the firm handled it, was a big deal for us.
Yeah. Well, yeah, we actually tried the case. But anyway, but so I've just had to reinvent myself constantly. And when Dominique joined the firm, I sort of felt a kindred spirit. And then Dominique mentioned to me, hey, there's a statute, and it's going to apply in California, and it's got a private right of action, and it's got statutory penalties. And I thought, wow, there's going to be a lot of litigation involving that. So Dominique and I started collaborating, thinking about ways that this statute, the CCPA, would actually result in litigation. And then now we've started monitoring CCPA litigation on a weekly basis. We publish an annual year in review to keep an eye on how this statute is basically becoming realized in the courtroom. And it's been very interesting. And I think it's really, unless I'm missing something, it's just the beginning, because you combine private right of action and statutory damages, and that's a recipe for class action lawsuits.
You're looking at me.
I am looking at you because when he's talking about reinventing himself, I feel like that's what you say all day long.
Yes, it depends on the day.
You've gone through many iterations as well.
I have. I've been a corporate attorney, which I still am, but then I've dealt with autonomous vehicles, drones, and the latest iteration of the blockchain, NFT. So, David, I understand where you're coming from.
Appreciate that.
David, you talked about the individual private right of action and that this is just the beginning. Share a little bit more about maybe what you're seeing out there. What are the issues that people are finding and trying to litigate against, and maybe some ideas of where you think it's going to be headed?
Yeah, well, I think Dominique represented the chamber, and as that bill was being drafted, and the legislature is very careful to make clear that the only private right of action was based on essentially what's called an exfiltration or a data breach, and it went so far as to say you really can't use this statute as a hook under some of our other consumer protection statutes, like we often do. In other words, you can't say you violated the CCPA and therefore you violated we would call it the unfair competition law. And so, but what we are seeing still, less now, but more, are plaintiffs' lawyers trying to test the bounds of what in fact is an exfiltration, or where in fact a private right of action may be available under the CCPA. That's number one. And I think that's going to settle out. That the statute is so clear that the plaintiff's lawyers are going to be unable to get those statutory damage hooks without actually finding an exfiltration. But the law is still a little bit unclear on that. And so that's where we saw the first sort of wave of lawsuits, was where people were, let's test the bounds of that. And there's been some decisions that have been handed down that have been fairly uniform in saying you can't expand the right. But still, there's other, state statutes, right of privacy, unfair competition law in general, that could protect you if you suffered some kind of damage. And so, as you know, the issue oftentimes in these privacy lawsuits is whether there has been any damage. And the good thing about the CCPA, if you're a plaintiff's lawyer, is damages are statutorily presumed. And so that's one thing we've seen, is ways that lawyers are trying to sort of find some sort of damage hook outside of the CCPA. And I'll shut up on this. This is a little bit kind of wonky, obscure, but it is relevant. It's the Supreme Court recently decided a case called TransUnion. You all may be familiar with that, but basically it just held that even if there's a statutory violation without injury, that was a Fair Credit Reporting Act statute, doesn't create an injury for purposes of Article 3 jurisdiction, which is the prerequisite for suing in federal court. Unfortunately, in our state courts, or I guess fortunately, depending on what side of the V you are on, Article 3 is not required. So, for example, you could have a violation of the CCPA. You could have no damage, but if you have the violation, that's enough to get you into court in state court. So what I think we're going to see is a lot more cases migrating from the federal courts to the state courts, because plaintiffs' lawyers would prefer to be in state courts, because state court judges tend to be a little more loose, a little more liberal. Class certification rules are easier. And right now, defendants will try to remove a case from state court to federal court. And plaintiffs' lawyers are saying, well, no, there's no Article 3 jurisdiction under TransUnion, and the courts are sending it back. So I think we're going to see a lot more litigation into the state court, actually, onto the CCPA now, particularly after TransUnion. Long-winded answer. Sorry, Jody.
No apologies needed. It sounds like the ping pong of paper.
So kind of building on what you're talking about, obviously there's several states where privacy laws have come back onto the docket this year. And if I recall correctly, in Florida, where that law floundered was on whether or not they would have a private right of action. What are your thoughts based on what you've seen, both of you, as to how a private right of action may or may not make itself into the bills from some of these states like Washington and Florida that are going to put privacy back on the docket in their legislatures this year?
So I have one little sort of backstory on the Florida bill. So as that was progressing and it was looking like it was going to actually get enacted, I had some business government affairs folks reach out, and they said, Dominique, we understand that your firm's keeping a litigation tracker or something. And so I actually gave them David's litigation tracker to be able to counter the argument that the consumer advocates were making, that the private right of action would not blow up into a bunch of litigation in areas that were beyond the data breach parameters. And so back then, this was 2021, the stats looked, I mean, we were sort of looking backwards to 2020. The stats looked like about a third data breach, or maybe 60% data breach, and then another 40% issues that had nothing to do with data breach. And so that at least put a little water in the wine of the legislature to give a moment of pause to the private right of action. And that's how that bill floundered. So I don't even know if I had a chance to tell David this, but that is actually what happened. And so those government affairs and lobbyist folks were really happy to have the tracker, which is on our website, that lays out these stats, because nobody else is really keeping it across. I've seen some smitters and smatters, but David's team, actually reads every complaint that mentions the CCPA or anything related to California privacy rights, and they document that. So they've got a really good handle on it. But I think the Florida bill just barely missed it. So I think that is a very close one to watch. I think that one is prime, as well as Washington State, for possible legislation. So, keep eyes peeled for that. But the private right of action is at the core of all of it. And I'll just say one last thing in terms of the federal legislation. I was literally just talking with Cam Carey over at the Brookings Institute and the R Institute with Tatiana Bolton. And, frankly, there seems to be sort of a coalescing on the federal level around what can be compromised potentially in a private right of action. It used to be that business was like, no way, we just don't want any private right of action. But now that California is already afoot, there's, some reason to believe that industry might soften a little bit. And if we can keep it with parameters, strong parameters, like, what the cases have borne out, as David mentioned, that it should just be related to negligent data breach only, that there might be an appetite for industry on the federal level to go in that direction. So really interesting times.
Well, Dominique, can I ask you both a follow-up question on that? And correct me if I'm wrong, but when it comes to the California private right of action, doesn't it really narrowly apply when you have a data breach and the data was not encrypted when it shouldn't be, as kind of the prima facie evidence of negligence?
Yep. And now that is the case. And I'll just turn it to David to talk about how last year, before they got sort of stamped down, the Plaintiffs' Counsel were trying to use things like cookies as negligent, or trying to say that those are negligent exfiltrations of data.
Yeah, they're obviously trying to expand the definition of exfiltration, and it is supposed to be unencrypted. And just you mentioned sort of prima facie. You'd think that if there was a leak and it was non-encrypted information, it would be almost prima facie evidence of unreasonable security efforts. But there is a prong that basically says that it's the burden on the plaintiff to try to prove that it's an unreasonable security measures. So, that's not as you likely know, that's not a defense you're going to win on summary judgment, because if it's a reasonable issue of reasonableness, they're going to have experts on one side, we're going to have experts on the other side. So I think the reasonableness issue is going to be one where you're going to see a lot of litigation. You're going to see a lot of sort of a cottage industry of experts on both sides talking about what is and is not reasonable security measures. And then just going back to your major question, if there ever is a state that passes a broader private right of action, such as Washington, it is Katie bar the door for lawsuits, really. And one, Dominique, remember we interviewed someone from Washington, D.C., and we said, well, when do you think there's going to be a national statute? And he says, there will be a national statute when some state creates a private right of action for any violation, because he said, then the feds are going to step in and try to shut it down. Yeah. So we'll see if that happens, but that's the prediction.
That's interesting. I'm always asked about the national law, and I have all kinds of fun answers to it. So I might have to add that one to my collection. One of the questions I was going to ask you was around this concept of reasonable and what is considered reasonable and what is considered negligent. Based on what you've seen so far, can you share a little bit of maybe some of the themes that are emerging of you do these types of activities, it's likely going to be maybe considered reasonable? I know there's no perfect answer, and I'm not looking for that. Companies just are always kind of wondering what is considered reasonable.
I don't know. I tend to agree with Justin that if it's unencrypted information and it gets out, it is almost prima facie evidence of it being unreasonable, because how else did it get out, right? It shouldn't get out. I mean, Dominique, you tell me. That's you tell people how to do this.
I think that, on the technical side, there's sort of two answers. On the regulatory enforcement side, with the AG's office and these notices of violation letters that are coming out, and even when the agency comes out, I think there's going to be a lot of looking at standards like, the CIS critical security controls, which back when VP Harris was our AG, she talked about in her 2016 breach report as being prima facie evidence of reasonableness. I haven't really seen any other AG take a departing point of view. The opposite, Attorney General Becerra said he didn't, now he's our Secretary Becerra, but he said that he didn't see any reason to depart from what she had put down. Similarly, I haven't seen AG Bonta go in a different direction. But I could envision for courts that it's not as clear, they're not necessarily looking at it as clear cut. So we have seen some cases where they're outliers, but they've made it pass motion to dismiss on things where, for example, there was one situation where the company had a do not sell link on their website, but had gotten a lawsuit claiming that it wasn't conspicuous enough. And a judge let that go through, even though that is not supposed to be there. So I just think that reasonableness, I mean, let me just say one other thing on this too, David. I remember, and Jody and Justin, I remember right after CPRA was enacted, and we were asked by Chief Justice Tani Sakaway to train the judges in Los Angeles as well as in Northern California. So we trained judges in Sacramento as well as in LA Superior. And back then, Chief Judge Brazil hosted us in LA. And the people speaking were mostly Alistair McTaggart, Senator Hertzberg, back then, now he's a judge, but Assemblymember Chow, a lot of consumer advocacy perspectives. And I think Alan Zarenberg, the former CEO of the chamber, and Jennifer Barrera, the current CEO, and I were probably the only ones holding up a business perspective at all. But I could just say that the judges were mostly nodding as now the current CCPA agency director, Ashkan Soltani, was explaining how tracking and cookies worked. The only questions we got were, how could they, disable cookies from their grandkids' phones? So from that perspective, I don't think things look great. I think David and his team are going to really have a tough job making it clear that we can't just depart from the law to try to find some way to address these issues, because there's the whole society around us that's pointing a finger at a lot of things related to data these days.
And you can always do something better. I mean, that's the point, right? So yeah, we have not seen any, say, a motion for summary judgment where, one plaintiff expert is saying it's unreasonable and one defense expert is saying it is reasonable. We haven't seen that, nor have we seen any kind of, third-party compliance as being, prima facie evidence of reasonableness. It just seems so, there's just no national standards, right? If there were some national standards on security, it might make a difference. You say, hey, listen, we comply with the national standards, and then maybe there'd even be preemption, but you don't have national standards. And, we just interviewed a guy who wrote this book for engineers. It's really a wonky book, but it's on how to develop privacy. And it is, Dominique understands parts of it. I don't think I could understand the first page, but it is really complicated to engineer for privacy. And I think it gets more complicated. And as the perpetrators get better at infiltrating, your defenses have to get better. So it's I think it's going to be an evolving standard. But I do agree, back to you, Justin, if it gets out and it's unencrypted, there's going to be sort of a presumption that it wasn't reasonable.
Well, let me flip the script a little bit. And we talked about what's reasonable. But Jody, I think for your benefit and the audience, is a lot of times we have to write laws and say reasonable because, particularly in technology and the privacy and security space, things evolve so rapidly. So my question for the both of you is, if we had this conversation, say, in 2019 versus today, what do you think of the argument is, well, multi-factor authentication isn't a standard? I think personally in 2021, at least on all the deals that I do, I have a requirement that a customer using a SaaS product is all of their employees are using MFA. It's just table stakes.
I like that, Justin. I just think that you're right. I mean, there's sort of three things at play. There's our or continuing increasing dependence on technology. We're doing this video cast podcast, on Zoom. We're conducting health, education, finance, everything through technology. So there's just a heightened, and it's going to continue. You talked about NFTs, and so there's just going to be a heightened reliance on that in the years to come. So then with that heightened reliance, you've got heightened angst, I think, by societal members about what is actually happening with this data, how is it being used, and can it backfire to hurt me as an individual? That is what I think is driving a lot of the consumer class actions and what we're reading about why privacy and data security on the front page of the news. So I bring it back to the third thing that I've been really interested in exploring these days, which is how does data relate to the brand, the value, the trust of the organization? So even if it's technically permissible, and even if it's in your rules and it allows you to do it, how is this going to appear in the broader public if it were splashed on the front page of the Wall Street Journal, New York Times, and David and I like to read the Financial Times too. So, and that's really what it comes down to. So to your point, Justin, yeah, there's nothing that says that you need MFA today or tomorrow, but how would you feel if it's your brand? And this is something that is industry, is happening in industry. It's totally available and you didn't do it. These are the types of things. And I just wonder if the corporate leaders like officers and directors even know the difference between what you're talking about, Justin, and sort of the whatever is reported by the CISO or whatever once a quarter.
Yeah, I definitely think there's a disconnect of a variety of different leaders, and throughout even the organization, you'll have companies who we've been talking about a specific individual right, but all of the other ones that obviously exist, right to access, right to deletion, should it apply to just those in California? Or what about Jody and Justin hanging out in Georgia? We don't have any rights. Do we get any too? And you see some companies that have decided to make GDPR level rights globally. You see some who have decided to make US, using California as the barometer across the board. And then other companies who say, no. Only if you're in California, that's it. And each of those decisions ties back exactly with what you just talked about when it comes to trust in the brand. What does the consumer expect? We could have a whole field day on cookie banners. We won't. But, right, should you have one? What should it look like? Why do you need one? But nowadays, customers have become accustomed to certain activities, and it's very tied, in my view, to every part of the experience. When I'm going to buy a product and service, I expect it's going to be a fabulous experience. I'm going to get what I wanted. I trust you as the brand. I think the thing is going to work, or you're going to do what you're supposed to. I also now have an expectation of what you're going to do with my data. And some people in an online advertising perspective might say, well, okay, you might follow me around the internet, collect all my data and serve me relevant ads. That's okay. Except until they understand a little bit deeper, potentially the type of data, or who else was it shared with, or if it was part of a breach, or it was shared with, my next door neighbor's new cool startup that had no security controls, then I might care. And so all of that is tied. And I don't think that conversation is well understood at even a mid-level in a company, let alone necessarily many of the executives.
Well, I guess I have a question for all three of you. So I was reading, so the Super Bowl had their ads and everyone was talking about them. So I'd like to ask all of you a question about the Coinbase ad. So that was where the QR code was just marauding around the screen for 60 seconds. Mm-hmm. And when you talk to the marketing people, they thought it was brilliant because everyone was trying to get on the QR code, so much so it crashed the site. But I'm thinking from a security perspective, really, you want to just have all these people with a phone to a QR code they know nothing about. What does that mean from a security perspective? And I just would love to get your perspective on how you see your role trying to navigate, knowing what some of the security concerns are, but yet dealing with marketing people who say, hey, we're trying to market, and hey, Dominique, Dave, you guys are getting in the way.
Yes, I am definitely used to being in the way, but I think that that actually the advice is more welcome. And I'm starting to see, I mean, David and I are speaking on Friday to a group of retailers about how to look ahead and look around corners and see things. I mean, this isn't in the financial context, but we were just talking to a financial institution last week about these same things. So I do think that there is an attempt by industry to look ahead and know more about what are the implications of these, what are the implications of what we're doing, so we can plan. And we've got another one on global litigation coming up for another major company. So I just think that, Justin, it's communication, and this is where, like, you and Jody and all of us here, on this call, and everybody listening really can play a very active role in bringing groups together rather than just listening to one side and the other. Get the security team in community and in collaboration with the marketing team so that there's always a conversation. And I feel like that's the pivotal role that those that are involved in data can play in an enterprise.
And more practically, Justin, what I've seen in the I do a lot of these consumer class actions is once these marketing people get put in front of a court reporter and have to swear to tell the truth, and they have to look at some of their PowerPoint slides and what they were talking about trying to sell and what they were talking about trying to do and explain that, it sometimes causes them to back off a little bit. And that happens a little bit, and the culture starts to change. And then we provide some obviously in-house training and say, hey, listen, these are things you got to avoid, and these are things you have to worry about. And here's an example how a deposition works, and what kind of questions are going to be asked. And you're ultimately going to have to own up to this at one point. And so I think that will have a deterrent effect. I don't think it's going to stop it at the front end necessarily. Dominique may disagree. I do like, we did speak to the one privacy officer from a very major platform, and he basically was all about trust. His first word was trust. He said, this is a brand, and people should trust our brand, and they should trust our brand, Jody, for everything that you said, and for privacy, for what kind of data they're collecting, what they're doing with the data, when they destroy the data. All of that was really, really great. And I think you're probably as things evolve, we do this example where you can particularly with companies in the GDPR, where you can look at all the cookies that are being downloaded on your site when you click once. I mean, it's unbelievable. It's page after page after page after page. I think if consumers really knew that that's what they were dropping out of their computer, they'd be thinking twice. So anyway, and then I'll shut up about it. But obviously, privacy is now kind of a marketing thing, right? We've got a couple companies that are giving, basically, it's opt in, not opt out, and that's changing.
On that note, what I was going to say, since you did say this, three of us, I count two.
Okay. What do you mean? You count double? I'm just here as an appendage.
That's a good point.
You've been carried away.
I'm seeing more companies create marketing compliance roles, and that sits in marketing. Whereas before, marketing might have been not as excited and welcoming to all of these new privacy laws, and they might have taken direction from those that were setting it. Now they're realizing, we really need to make sure that we're doing the right thing, proactively integrating all of the expectations from customers, from legal, and they're creating these marketing compliance roles, which I think is a sign of where we're headed and makes me really excited.
So I'm going to ask one last question, and this is more on a bit of a personal level. because we've talked about privacy in the ad tech space. So as we talk today, last year, the Biden administration passed the American Rescue Plan Act to help modernize cities. And you're going to see things starting to come out. I've seen it already. Digital license plate technology and cameras. The one that really scares the crap out of me is putting facial recognition software on a drone with a camera. And so my question to the three of you, as we start to think about privacy, and I'm out driving my car in the right of way, and there's a drone flying overhead, and it's taking video of me in the right of way and can figure out where I've been, where I'm going, and all of this information is being gathered. What are the implications there for privacy? Because I'm watching the drone industry and really not think through it, much like previous industries. How do we, as a society, start to figure out how to educate ourselves, like all the cookies we just talked about? Think of all the drone footage on a daily basis with facial recognition technology software. Where does that get us?
Well, we had a guest on our podcast, Professor Barry Friedman at NYU, and frankly, he was just laying out that some of the stuff is already happening in Los Angeles with our law enforcement. So we already have a lot of that data being hoovered up, and then we had a chance to speak with Eileen Decker, who is the president of the LA Police Commission, and she talked about the context and the access controls in place and so forth. But these are really tricky issues, Justin, super tricky in terms of how the data is going to be used, who it's going to be shared with, what are the access issues. And frankly, we haven't jumped into this, but the whole algorithmic fairness thing. And that is just getting to be such a huge topic. I saw Senator Booker just introduced a bill last week, and it's just something we've been thinking a lot about. So you're right to, raise these things. I do think that the drone industry is being, sort of brought into community with privacy. I know this is something that's been talked about, but there are issues. I mean, how are you going to be able to really screen out things like facial recognition when you're using drone technology?
Yeah, they better not run those drones in Illinois. They're going to get in a lot of trouble. They do it. They have to circle that one state off because of that Bioinformation Protection Act. Mm-hmm. There's the big penalties under that one. And yeah, we'll see. We'll see. I do think that the facial recognition technology is. I think people are pretty sensitive to that. It's funny. We interviewed a guy. He was pretty good interview. We'll shut up. But his job, he was called an open source investigator, and he had this whole group of people that just sat on the internet all day long, surfing for like atrocities, like human rights atrocities, and really some horrible things like executions and whatever. But then he would use that information, and then I basically track back and try to identify the perpetrators or identify some of the victims, and using all this public information. But he did talk a lot about sort of the tension, because he says, I can use this information for good, but others can use this information for bad. And it is an interesting tension, Justin. I don't know how it's ultimately going to resolve, but you raise a really, really interesting point.
Well, I think as a privacy community here, our little group of four will have to continue to include the conversation, raise these issues, and collectively make sure that other industries learn, hopefully, from prior industries.
Yeah.
So with that being said, we always ask our guests, when you're at your cocktail party, gathering, however, what is the best privacy tip that you might offer?
Well, I'll just start with what I was mentioning earlier. I just really encourage people I'm talking to that are in the industry, and I hate to say it, but a lot of the cocktail parties I go to are also people doing privacy and cyber. So I'm sure it would be so nerdy.
Dominique, we need to get your social life expanded.
I need to go with Adam's friends. my husband. But anyway, when I'm at a cocktail party, I often just encourage colleagues to interject themselves into the conversation, and particularly as it relates to data and the strategy of the enterprise. And so I really would love to see more chief privacy officers, more folks, chief information security officers in community with C-suite, board members, et cetera, who are discussing strategy and how to maintain strategy, to pose the question of what data is needed to get there. And then actually that will sort of unfurl, I think, a whole series of communications that will be beneficial to both parties. And so with that, it's really the idea behind a global data innovation team I started at the firm, and David and I are on it. And our first meeting is on February 28th to just, unpack this and make it easier for corporate leaders to get educated about these things, and for those, folks such as yourself, Jody and Justin, who know the area, to be able to help demystify certain things. So that's my tip.
It's a great tip. David, do you have a tip?
Yeah, of course, none of the privacy professionals are going to find me at any party, so I'm always there with a bunch of laymen. So what I do is, Dominique's got this chart on how ad tech works, and what is ad tech? Is how many $billion industry is it?
$800 billion global.
$800 billion. And most people don't even know it exists, or if they know it exists, they have no idea how it works. And I just say, you got to look into this. You got to just see how it works. And I can show them Dominique's chart, which is, it's head spinning because there's so many dotted lines and all, you can imagine the intermediaries and stuff. But I think it's really important for laymen to sort of just understand how that industry works, that it exists, and how it's used. And you make your own decisions about what you want to do. But I think just understanding that industry is really, really important. And I think it's I think the understanding of that industry is very limited still, even today.
I completely agree. It's amazing what people think they understand. They really don't know what is underneath, how it all works.
Well, our last question is, when we're not talking about blazing the path for cybersecurity and privacy awareness, what do the two of you like to do for fun?
Okay, I'll go first again. Well, I love to travel. So it's been inhibiting the last couple of years with the pandemic, but we were able to get out to Europe in November for just a little window of time in between variants. And I'm hoping to be able to do some more travel this year. And so what's on the chalkboards is potentially Sicily.
Wow.
So Adam has a film that is getting put together, and so it just depends on timing and all that. But if the stars align, then I would join him in Sicily and be able to see that part of the world, which I've been to Italy, but never Sicily. So I'm excited.
That sounds really lovely. You can bring us back some pasta, please.
No kidding. No kidding. Yeah. All right. So real quickly, I like to exercise. That's what I do. All right. Because it's a de-stressor, and I got to do it every day. So that's I don't know if it's fun, but it's a necessity in my life.
Oh, well, Justin would love to exercise, I think, all day long.
Oh, yeah. Oh, wow. It's cool.
Well, thank you both so much for joining us today for a really fascinating conversation. If people want to connect with you, where is the best place to find you?
We have our Decrypted Unscripted podcast page, so I can share that with you, and maybe we can put it in the show notes.
Absolutely. We will put it in the show notes.
And we need to have you on our podcast.
Yeah, you guys are going to come on our...
Yes.
Yeah. So now we're going to get to ask you all these questions. But we'll start out with, what do you do for fun?
We look forward to it. Well, thank you so very much.
Okay. And we'll be in touch to schedule.
All right. Thanks for having us.
Absolutely.
And, talk soon.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.